Yes, ma'am.
Item number 1.
Yes, please.
May it please your lordship.
Yes, yes.
That in this matter, we were asked to file an affidavit to explain certain circumstances as to why, although the vacation benches were available, yet permission of the honorable vacation benches were not obtained before the demolition of the structure was done. Your lordship will recollect that this pertains to that school building, my lord.
Yes. Where is the affidavit?
My lord, we have filed it, my lord. It is,
It is 17.
dated
17.
February, 17th March.
17.
The affidavit is dated 17th March. I can take your lordship to paragraph number 3.
Who has affirmed the affidavit?
The member of the managing committee, all of them have filed individually, 5 of them. So the name is brother
17th March.
13 March. One of them is brother Dionytus Fernandez. Number 1.
Yes.
I very humbly submit, the circumstances were such, and it happened in such a way, Millard. There was no scope, Millard. What has happened, Millard? Actually, before the matter came before your lordships here, in the month of November only, after obtaining the requisite permissions and all that, the procedure was started on 25th of November. And thereafter, the matter came before this, the motion was on 9th of December, Millard. After 9th of December, Millard, they had not done anything. But on the 4th of January, in the morning, Millard, when the building was found to be in a very precarious condition, so an effort was made to straighten the building. And in the process, Millard, the building collapsed. So it was not an intentional act of demolishing the building. In our humble submission, we were not in a position, not in control of the situation at all.
Please take the. We have carefully gone through the affidavits filed by the alleged contemners. Next. By our order dated 24th February 2025, we had directed this affidavit to answer the following queries of this court. Pencil mark in this order. Page 2 to 3 of the order dated 24th February 2025. The affidavits state that the alleged contemners have the greatest respect for this court and the orders passed by it. Full stop. At the outset, they tender an unqualified apology and pray for forgiveness. Respect for this court, thereafter you add, they had and have no intention of disobeying its orders. Continuation. On 4th January, the building was found to be tilting. Full stop. They sought the advice of a contractor who opined that it be demolished to prevent danger to life and property. Acting on that advice, the building was demolished. Full stop. As the danger, according to the opinion of the contractor, was imminent, the court could not be approached. Paragraph. We do not find this explanation wholly convincing. Paragraph. Nevertheless, the alleged contemners are respected priests attached to a very distinguished institution. Christian priests. Next slide. Jesus Christ taught us that forgiveness reaches more satisfaction to a person than the, no, you cut it out. Jesus Christ taught us that taught us to forgive and full stop. The satisfaction one gets out of forgiveness is much more than what is reached by inflicting the pain of punishment. Full stop. My religion, Hinduism, also has similar teachings, makes similar teachings. Full stop. We also appreciate the manner in which Mr. Chakraborty presented the affidavit of the alleged contemners, which impels the court to forgive the alleged contemners. After all, in the exercise of contempt jurisdiction, we are not above God, and the prerogative of forgiving even an unacceptable act is with the court. Paragraph. Therefore, considering the status of the institution in society and of the management of the institution, we dispose of this contempt application without proceeding any further with it. Full stop. However, it is with the rider that the management of the school will strictly comply with our order dated 24th February 2025, which is the material part of which is extracted below. Mark number 2. That will rebuild with the same plan. With the building will resemble the old building. This part. Contempt application disposed. Yeah.
Highly bless you, Lordship. Very good.
Yes, the public interest litigation is also disposed of.
Number 2.
Lordship, there are two connected appeals, Lordship.
Yes,
In item number 2, Lordship, I am appearing for the respondent. Lordship, I am praying for a day's accommodation, Lordship. Learned Senior Mr. K. Paul is leading in this matter, Lordship.
when is he joining court?
Lordship, he has joined yesterday, Lordship. Today he was supposed to be here, but due to some personal difficulty, Lordship, he could not be here. He could not come. Lordship. So I'm
21st is
praying-
the last ceremony. 21st of this month is the last ceremony.
Any date after that, as per the convenience of your Lordship.
By consent of learned counsel for the parties? Come on the personal ground of Mr. Paul, learned senior advocate appearing for
He is appearing respondent in the
For-
first
for-
item and appellant
ground
in
of the personal ground, appearing for one of the parties. These appeals are adjourned till 25th March, Tuesday.
Lordship.
Number 3,
Lordship. This is with regard to the appeal of the judgment on order dated 18/4/2024 passed in the petition 474 of 2022, Your Lordship. The petition was with regard to the rejection of the application for drilling of water, Your Lordship.
Sorry?
The petition was regard to the unjust rejection of the application for drilling of groundwater for domestic use.
Dealing of?
Drilling of groundwater, Your Lordship.
Yes.
So the appellant had submitted a application on 19/7 of 2017, Your Lordship. There was no action taken by the respondent authorities. And in the course of the petition, Your Lordship, the respondent number 1 in the affidavit, that's at page 101, Your Lordship, of the appeal. May I read, Your Lordship?
You are ready to proceed with the appeal?
Yes, Your Lordship.
All right. Pass over at the first call. Call the next matter. You just wait. We are coming back.
number 4,
May it please your lordships, I'm praying for a week time in this matter, as the conducting counsel, Mr. Sen, is unavailable due to some personal
You have not
difficulties.
increased the sound. How more forward they will go? You call the IT chap here. You all can't do anything by yourselves. In everything the judge has to interfere. So why don't you check it? Then the voice is not loud enough. Everything the judge has to do.
But you see, the lawyers should be responsible enough to understand what the lawyers also should understand what is.
What they will do?
Some he stand too far.
No, she's all right. That distance is all right. She can't lunge forward like this.
Apologies, your lordship.
Yes.
May it please your lordships, I'm praying for a week time in this matter, as the conducting counsel, Mr. Sen, is unavailable due to some personal difficulties.
You are for whom?
For the respondent,
For the
Your Lordship.
respondent, Your Lordship.
Huh?
For the
Respondent, Your Lordship.
respondent writ petitioner, Your Lordship.
Twenty 24th, on the prayer of learned counsel for the respondents. This appeal is adjourned till 24th March.
Highly obliged, Your Lordship.
Number 5.
May it please Your Lordship.
Yes.
Lordship, last time Your Lordship was kind enough to correct my paper book because there was
No,
certain.
you are ready to proceed with the appeal
Yes,
today?
yes, yes. Well, whenever Your Lordship,
No, no, we have passed over the first appeal.
Yes.
Because they were ready for hearing.
yes,
So this is just a first call to find out which appeals are ready for hearing today.
yes. But Your Lordship, if Your Lordship wants a next date, I'm ready.
No, what's the next date?
First
So if you are ready with the appeal, this will be passed over. This will be the second appeal in the list to be called today.
Okay. Okay.
If you can wait, it is all right. Otherwise, we will adjourn it for the day.
Can it be an adjourn for a day, my Lord, if it is not inconvenient to Your Lordship?
All right, passed over for the day.
Yes.
Next.
Can only with Your Lordship's, if it is not inconvenient, can a date be fixed, my Lord? If it is not
It is
inconvenient.
fixed. Passed over for the day means it remains in the list.
Oh, acha, acha.
It will come
But
tomorrow.
in all probability, it will be called on Monday. Tomorrow not possible, perhaps.
So that
There's a
might-
different bench.
Yes, well, if it is on Tuesday, because I'm from Guwahati, my Lord, if it is not inconvenient to Your Lordship, my Lord.
Mr. Advocate General?
Your Lordship may have it. Oh, sorry, calendar is this side, Your Lordship. Now, Your Lordship, I was praying that Tuesday, may I be permitted to join on by VC on that day?
Yes. By consent of learned counsel for the parties, this appeal is adjourned till 25th. Considering the manifold responsibilities of the learned Advocate General, he is allowed to argue the matter virtually.
Grateful.
I am deeply obliged, my Lord.
Second call, item number 3.
Lordship.
Yes.
The repetition was against the unjust rejection of the application of the
Where is
appellant.
the improved order?
Page 161.
Who's appearing for the respondents?
For the state respondent 1 to 4, Your Lordship. And my senior
Number
lordship,
5, the village authorities.
No, who's in charge, who's appearing for, which is the authority responsible for this boring, giving permission for boring wells and all that?
boring has been done by the state respondent. Then we have already handed over the distribution of water to the private respondent number 5, Your Lordship.
Your Lordship, if I may.
Private respondent means?
This is the
Previous number 5,
This
this
is the-
village authorities. Under the KGM scheme, about installation of infrastructure, construction of the dam, it is a duty of the government. And for connectivity with each household is given to the village authorities. Now connectivity has to each one of the village household has been done. But the water source has yet to be handed over to the village authorities.
Where is the writ petition?
It's at page 39, Your Lordship.
This is under which department of the government?
PHED. PHED, you know. PHE.
Public Health Engineering.
Yes, Your Lordship.
There is a secretary. Secretary is there.
Yes, Your Lordship. Secretary is there.
Because what is wrong with this order? The only thing is that they are not specified the authority which will consider. Otherwise, they will take them for a ride. Let somebody consider whether this government supply is sufficient or not. Otherwise, board will permission be taken. They are saying it is sufficient. That's the reason. Somebody will decide and pass a reason order. That's all.
Your Lordship, if I may, with regard to the extraction of ground.
See, this court will not take up the exercise of number 1, ascertaining whether the government supply of water is sufficient or insufficient, or if it is insufficient, to what extent it is insufficient, 10%, 25%, 50%. On that basis, borewell permission will be given to you. If it is sufficient, nothing. If it is insufficient, then your case will be considered.
It's not sufficient, Your Lordship, as per the
Will the writ court take evidence to find out?
it did not.
No, Your Lordship. The operative part is of the impending order. Operative part is para 7, page 163, Your Lordship. Operative part is para 7 of the impending judgment and order, Your Lordship. Then please read, Your Lordship, the operative part para 7.
163.
163, page 163 of the writ appeal.
No, that we have seen. But to whom he will go is not specified. The executive engineer will not give him any relief because he has already refused. It will be a idle, futile exercise to go before him.
Your Lordship, if I may take Your Lordship to page 76, Your Lordship. It's the guidelines provided by the Central Groundwater Authority.
We know we have dealt with these cases before. Number 1, sufficiency, insufficiency. Number 2, if there is a nearby borewell, whether your borewell will affect the drawing up of water of the nearby borewell. All these things are taken into account.
In fact, Your Lordship, there are numerous numbers of commercial suppliers in the area. So the question of limited underground water supply is wrong, Your Lordship. Even in the impugned judgment, Your Lordship, reliance was placed on photographs of connection, but no water flows through those pipes, Your Lordship. The last water received by the appellant was on the 7th, only for about 7 to 10 minutes.
Please take note. You reside there.
In that
You
area.
do business there.
Yes.
You reside.
Yes, Your Lordship.
All right. The appellant wants a private borewell in his place of residence. Full stop. The respondent authorities have denied him permission to make this borewell, the ground being that there is existence of a public borewell, namely PHEG borewell. To supply water to the premises of the appellant. Full stop. The appellant's complaint is that such supply is almost absent. And that a private borewell is necessary. Full stop. The respondent authorities maintain that the supply is sufficient. Paragraph. On these disputed questions of fact, the instant writ application was filed. Full stop. It was disposed of by a judgment and order dated 18th April 2024 by a learned single judge of this court. Paragraph. The writ petitioner appeals from that order. Paragraph. Paragraph. We find no infirmity with the order passed by the learned single judge. Quotation, underlined part, page 163. Paragraph. Nevertheless, we are of the view that if the appellant is to be relegated to the respondents, to decide the question, the appropriate authority to take the decision should be indicated. We are not minded to assign this task to the respondent numbers 3 and 4 as, having already rejected the appellant's application, they are likely to be predisposed they're likely to have a predisposed mind. Accordingly, we direct the Secretary, PHE Department, himself or by an officer designated by him to decide the following questions. I is the supply of water from the PHED borewell sufficient to meet the requirements of the appellant? II. If insufficient, to what extent it is insufficient? Three, if the finding is that the supply of the PHED borewell is insufficient, then how could the required quantity of water by the appellant be met? Note of interrogation. Whether by constructing a private borewell or by any other means. Next main paragraph without number. The adjudicating authority should bear in mind that the requirement of water for drinking, washing and other purposes is absolutely essential for a human being, and that such right is now recognized as one under Article 21 of the Constitution of India. Paragraph. The above adjudicating authority will bear the above observation in mind and answer the questions before it by a reasoned decision upon hearing the necessary parties within 8 weeks of communication of this order. we clarify that the decision if the situation warrants shall contain a direction for supply of water to the appellant. The impugned judgment and order is modified to the above effect. The appeal is accordingly disposed of. No order has to pass.
Your Lordship, I pray that 1 month may be given to the responding authorities.
It is too short a time. They have to give notices, call parties, hear them, pass an order.
Lordship.
All right, make it 6 weeks. Prompt communication.